Hi there and welcome. In last week's video, I gave my position on the facts of this case, as we know them, that within the courtroom itself, the judge was the architect and prime mover in what was a premeditatedly unjust trial. This week, I want to share some thoughts and pertinent questions which arose in ruminating over the reason he gave for excluding the strongest piece of evidence available to Miss Letby's defense, the Royal College of Pediatrics November 2016 service review of the hospital. Had there been forensic evidence to support the charges, or if witnesses were available to tell the court they saw her harm babies, the document would have been totally irrelevant. The absence of those two elements, and the medical evidence being at best speculative, however, raised the evidential value of the document, making it the most important piece of evidence in the case. The reason that the judge gave was that the service review, to be precise, the conclusions of the service review, was not material to the case. Material in this legal usage means something which will tend to progress the court's quest to establish the innocence or guilt of the defendant based on a reasoned and rational assessment of the facts of the case. The Oxford English Dictionary defines the use of the word in this context as follows, I quote, "of evidence or a fact, significant or relevant, especially to the extent of determining a cause or affecting a judgment," end quote. This is what Goss said, making a poor show of hiding his partiality, corruption, behind big words and phrases, strung together, just like Johnson KC's catalogue of opening statement lies. I quote, "I'm going to have the details of the particular cases which are relied on for the general propositions that are advanced by way of conclusion in the report to see whether they have a materiality to any allegation in this case," end quote. Like the weasel of a man that he is, he then goes on to shift the onus of the question of the materiality of the service review onto the prosecution. A laughable posture, given that he is the judge and therefore calls the shots. I quote, "Because I rather anticipate that the prosecution will say that to be admissible, this has to be relevant to an issue in the case," end quote. Might a judge who was not pursuing an unspoken extra-legal and extrajudicial agenda also have anticipated that a reasonable answer to any such prosecution objection, once it had materialized rather than just being preempted to serve his own purposes, would be that the review was invited less for investigation of the spike in deaths than investigation of the named nurse whose senior neonatal unit staff were adamant was the one common denominator in those deaths and collapses. This video is not about analysing Goss's statement on the RCPCH report or his general bad faith in relation to Miss Letby's case. The former is simply the hook on which the thoughts I will share and the questions I will raise hangs, and the latter fact will already be self-evident to the bolder spirits out there, and at least gnawing at the edges of the consciousness of those who are not yet willing or able to challenge socialized ideas around the reverence of societal authority figures like judges. People who, in the final analysis, are simply old men and some women who still find it safest to go about their business in fancy dress because they are so acutely aware of the conflicted nature of their role, that of basically mediating between the good people of England and the British state, for which the people have ever been a means rather than an end, in order to finesse and generally paper over the ceaseless abuses of those people by that entity. Their dirty work can then be done from the safety of the collective persona associated with that fancy dress, thereby facilitating the evasion of personal responsibility for the violence to individuals and society of reprehensible decisions they sign up to take as and when necessary in the interests of whoever happens to control the levers of state power at that given point in time. Nevertheless, primarily for the benefit of any viewer for whom this video is their first non-mainstream input on the case, I must, in the interests of completeness, highlight a further aspect of Goss's subterfuge. Having begun his play with mealy-mouthed circumlocutions to build his confidence in his ability to bring off the evil he is intent on doing, he then distances himself from the evil act by metaphorically holding up his hands to say the call on the RCPCH service review is down to the prosecution. Then he finally gets down to brass tacks, showing his hand by laying the groundwork for the intended ruling out of the report in jarringly colloquial terms and some curiously stilted phraseology by which he further insulates himself from his evil by insinuating to Benjamin Myers that the unfortunate state of affairs to come, the rejection of his application to have the service review included as evidence, is somehow his fault. The phrasing is passive, neutral, or qualified throughout, even where the personal pronoun I is used. He takes no ownership for his decision, totally outsourcing all responsibility, the surest red flag that a speaker is engaged in evil. It is never, I did this or I am going to do that, but he, she, you, they, it made or makes me do it. He is all over the place in his shame, washing his hands of his intention to fatally wound the defense case. I quote, "So I'm only saying this so it's out there for everyone to consider when we come to deal with the report. So I'm sure you were alive to that, Mr. Myers. I would be staggered if you weren't, but that's what the focus is going to have to be on. It's not good just having bald assertions that there were shifts when there was understaffing and that sort of thing. But if that's not a shift that is pertinent in this case, what is its materiality to this particular case?" End quote. Who is the everyone that will need to consider this? There is himself, the decision maker, and the two parties, the position of one of which is being argued to him, and the position of the other he has said he already anticipates. General propositions and bold assertions. The Royal College of Paediatrics and Child Health is the professional body for paediatricians in the UK. It is responsible for all postgraduate training of paediatricians and works closely with the General Medical Council and the Department of Health. There was no more qualified body to conduct the review in question, and such reviews are, moreover, one of its core functions. The review was conducted by medical professionals who were peers of Miss Letby's accusers in seniority and necessarily more qualified in this area in consequence of their experience of conducting such reviews. Nonetheless, this man, with no more knowledge than a doctor would have had of the arcane rules governing the conduct of a criminal trial, finds it appropriate to dismiss the conclusions of his peers in a totally alien professional field on the opposite side of the art-science divide as general propositions only, and fully verifiable information such as how many nurses were at work on a given day historically as bold assertions. These postures would be outrageous enough after he had read the service review. He, however, made the observations in response to Benjamin Myers' offer to supply him hard copies of the report to read. He therefore took this position without even reading the report. From a purely procedural legal rules perspective alone, the service review is directly pertinent to the principle of causation, a requirement for any murder conviction, though not for an attempted murder one. I will not go into it again, having gotten a sense from a previous video, or from the previous video, the way it was received, that viewers find analysis of legal principle a bit too technical. For anyone interested in seeing just how outrageously the 3 required principles for a murder conviction were relaxed by Goss in order to convict Miss Letby, please see that video, that previous video. It is titled "Murder Requires an Identifiable Guilty Act. It must be proved as the cause of death. Where is it?" This calling out of Goss's emotional dishonesty in his evil was intended to be a brief introductory thing, but took on a bit of a life of its own. I hope I didn't test the patience of the well-informed too much, but as I said, not wishing to take anything for granted over how long before Miss Letby is freed, I thought it important to make his wrongful conduct as clear as possible to those encountering this video from a previously uninformed position. I will try to balance things out by being a bit tighter in now dealing with the originally intended main subject matter. Basically, reflecting on Goss's contrived reason for excluding the RCPCH report, I got thinking about the materiality of some of the stuff which did make the cut as acceptable evidence in this case. The statements from the parents. The first thing to say about them is that they are nothing more than victim impact statements. A victim impact statement is formally defined as a written or oral statement made as part of criminal proceedings which lets the victim speak during the sentencing of the convicted person or even at a parole hearing. Something, by the way, I consider pretty outrageous. There is a set tariff for a crime, any crime. That is the punishment the defenders baked in award for the offence, something which he or she theoretically was in a position to use to make a rational decision whether to do the crime or not beforehand. That should be the benchmark, not some later shifting of the goalposts where the victim gets to morbidly exercise control over an already punished person's life as an easier option for psychological gratification than making the hard choices involved in getting on with their own. Where does that train go next? To a place where the convicted person gets the option of having a telltale facial tattoo, or cutting off a couple of fingers to satisfy the self-absorbed vindictiveness of the victim to finally get free of them. All this with the state gleefully performing as the most enthusiastic of proxies, knowing that it is actually progressing by stealth the agenda of those it answers to. If I seem unsympathetic to this scheme, you will soon see why when I get to how it was openly abused by the CPS to secure Miss Letby's conviction. Also, like it or not, we can all go wrong, and redemption is possible for everyone except those unwilling or unable to accept the possibility for it in others. The reality is that victim culture is just another means by which the state surreptitiously maintains and extends its control by keeping some individuals stupefied by their preoccupation with their newly minted professional victim identity, while extending its overall control of society by using its status as executive proxy for those on the victim side of the ledger as the pretext to broaden and deepen its control over the lives of those on the other side of the victimhood equation, the criminals or deviants. Deviants are, by definition, the most likely to question or even openly challenge the state's stealthy incursions and subsequent occupation of all aspects of certainly of more and more aspects of private life. Anyway, what they now term the victim personal statement was introduced as the victim impact statement by the 1996 Victims Charter. The argument was that it personalized the crime and elevated the status of the victim. True enough. From the victim's point of view, it is seen as valuable in aiding their emotional recovery from their ordeal. The key thing about the new provision, though, was that to preserve the right to a fair trial that defendants used to have, the reading of the impact statement was conditional on the jury returning a guilty verdict, meaning said impact on the victim was ring-fenced as a consideration exclusively pertaining to sentencing. As a final general point on the genesis of the victim impact statement, I find it curious that in our commercial and employment lives, where we experience wrongs equally traumatizing, like our quality of life being permanently reduced by lifelong health conditions, and where there is a relationship of trust to boot, we don't have equivalent provisions. Why, after a success at a tribunal or in civil court, are we not afforded the same blank check time-wise to get payback? An injury is an injury after all, whether the remedy is under criminal or civil law. It looks to me like further evidence of the corporatocracy's hidden control of politics and therefore government. Increased government access and control of individuals furthers their interest as government is their tool. But corporate entities being bonded in perpetuity for their own wrongs was never going to be allowed to be part of the program. To return to the parents in the case, ultimately, these utterances by them to police were accounts, I can't even call them statements, requested 3 to 4 years after the event on the psychologically seductive premise of being an opportunity to externalize all their issues about the traumatic event. It won't now be down to health issues of the mother or the child. It therefore neatly avoided the need to endure the painful process of growing as persons in order to get past the event, given it was nothing to do with them. They were simply victims whose child or children had been attacked without their knowledge. Such utterances are not evidence of anything except the enterprise to frame Miss Letby. These are solicited accounts introducing an immediate confirmation bias on top of obvious issues of selective memory, false memories, and the plain total absence of recall which we saw so much of from trained medical professionals on the stand. The best example of that confirmation bias is of course the despicable claim the mother of child E was persuaded to make at least 3 years after the event, that all of a sudden she recalled almost catching Miss Letby harming her child. A statement which even the most cursory analysis shows actually says absolutely nothing, but nonetheless would have been music to the ears of the hardcore pro-guilters among the jurors. On top of that, These were people naturally in great distress over their child or children at the time, and therefore doubly emotionally invested. In all the circumstances, a less reliable witness would be hard to imagine. Fortunately, none of them being medical professionals or having detected anything suspicious at the time, none of these parents actually had or could have had any evidence to offer. None had anything to say which could not have been gleaned from administrative files, the medical files or case histories of the mothers, or could not have been given more competently by members of the nursing team or doctors who were in attendance at the birth or at the collapse events. That did not, however, stop what they did have to say from preposterously and quite pathetically being admitted as evidence, though. In reading case reports previously on Tattle Life, before they suddenly and mysteriously limited access to them about, 6 weeks ago, I had studiously avoided the evidence from parents, which is invariably prominent, or was invariably prominent in those reports. I did this in part because I made the reasonable assumption that the passage of time between the events and their accounts, them not being medical professionals, and the intense emotions involved meant their accounts would be drivel, contributing nothing to my understanding of the case, and in part because, even without properly looking into the question of the presence of such testimony in the actual trial, I intuitively knew they were simply victim impact statements being unlawfully abused, or certainly procedurally abused, by the prosecution to emotionally impact jurors. I also take no pleasure in getting up close and personal with people reduced by the cynical into unknowingly exhibiting the least morally evolved aspects of themselves in public. In the interest of fairness, research and due diligence, though, I took the time to fully read one of them for the first time, choosing the first to be presented to the court, that of the mother of child A and child B. What I read began as a simple factual account of how she came to be giving birth at the Countess of Chester when, due to a blood condition, which the jurors naturally were left entirely in the dark about, the original plan had been for her to give birth at an out-of-town specialist facility. Beyond that, it was a bystander account of her being around the unit and watching staff working on her babies and describing the natural distress any mother would experience in those circumstances. She then goes on to talk about, curiously, embargoing any family member from seeing her babies before she did, despite the fact that she was so poorly after the birth that it wasn't until the next day that she could go from the maternity unit to the neonatal unit to see them, and then only in a wheelchair. Her evidence culminates with her describing that when asked to authorize the ending of resuscitation efforts, she couldn't bring herself to say the word and resorted to nodding, or a nod. Some unfortunate member of staff, still laboring under the delusion that honesty is a virtue, then told her in conversation that if the post-mortem was inconclusive as to the cause of death, child A's death most likely was a consequence of that mysterious blood condition. The mother evidences to jurors that she was furious and sought answers. What I heard was a victim impact statement, not even a good one at that, as the claimed killer, Miss Letby, wasn't mentioned even once. Directly following on, we get the father's version of things. That wasn't wholly unexpected, and 20 minutes into it, 50 minutes after the mother had first taken the stand, we finally get a mention of Miss Letby. What I wasn't expecting, though, is that the grandmother then gets a turn. Again, as expected, nothing is said which is remotely evidential or hasn't already been said in the same or or a slightly different combination of words in the preceding two accounts. The sole discernible purpose is that 80 minutes get spent grooming the jurors emotionally, if not flat out bludgeoning them over the head with an emotional hammer. In conclusion on this point, I would ask the many persons who tuned into media coverage of the breaking story on Friday, 18th August 2023, to briefly cast their minds back to that sunny afternoon. You will recall that it was already mid-afternoon when the verdict came in. My first comment, or certainly was reported, my first comment on the case, expressing horror, was made immediately. My YouTube history shows it timed at 2:28 p.m. So less than half an hour into the afternoon session, normally ending at 4 p.m. The sentencing was on the next working day, Monday the 21st, and my comment on her not being present for sentencing is timed at 1:36 p.m., meaning that the sentencing must have happened before lunch. With the day starting at 10:30 a.m., that gives us about 4 hours between court time between conviction and sentencing. I've just described how 3 victim personal statements took 80 minutes. Is it conceivable that the court could have run through those of 28 parents in 4 hours? If so, why did the BBC, etc., not have more to say about them? I remember no coverage. The reason the media did no reporting on victim personal statements being read in court to inform the sentencing decision is that what was actually heard in court, of the half a dozen or so I had the stomach to read, were not victim impact statements, but short, nastily vindictive gloats, which would have tended to alienate the sympathy of the public from the parents. With the exception of the father of child G, who comes across as a thoroughly decent human being, retaining his dignity by speaking only of his tragically brain-damaged child and not joining the lynch mob, what the court heard were outpourings of visceral hatred. It was a biblical stoning, but with words instead of stones being thrown. The only tears involved were triumphalist ones of pleasure in the activity. As stated, I can speak only of those of the child G, but unlike what was heard during the trial, as I said, these were not victim impact statements, just individual Orwellian 1984-esque 2-minute hates, more likely to influence an honest judge towards leniency towards the convicted defendant than to be viewed as an aggravating factor calling for the full extent of the available tariff in sentencing. Clearly, in abusive process, the actual victim impact statements had already been presented to the jurors as spurious evidence during the trial to groom them and as emotional blackmail. They had done double duty as witness statements to influence the jurors towards a guilty verdict. Tell me this is not shameful. So what we have then is an investigation, a prosecution, and a trial shot through with the benighted principles that any 17th century witch hunter would immediately recognize. The most important and authoritative piece of evidence is ruled inadmissible, while it is pretended that the rawness of the emotional excesses of persons duped while at their most psychologically susceptible somehow qualifies the description of those feelings to be transmuted into evidence. It is an utterly scandalous and thoroughly shameful state of affairs for a developed society in 21st century Western Europe to find itself in. It is as if the Renaissance of Michelangelo and Leonardo da Vinci and the later Enlightenment both found the English Channel an insurmountable obstacle. The unnoticed reality is that the only thing saving this prosecution and all associated with it from utter ridicule is the fact that it was successful insofar as an innocent woman is languishing in prison wholly through the activities of a corrupt judge. It is to a credible and compelling prosecution case what Eddie the Eagle was to ski jumping, or Inspector Clouseau is to police work. Okay, that's what I had to say to you today. As usual, feel free to share your thoughts in the comment section below. And again, as usual, thank you for watching. Thank you for your time and all the best.